with the process of elaborating an envisaged final constitution. By 16 February 2000, consensus was reached on a list of 27 constitutional principles that were adopted to guide the drafting process. A final draft was published 4 years later in January 2004, only to be discarded with the decision in 2008 to hold general parliamentary elections to constitute a fresh constitution-making mandate for Parliament. And the newly elected Parliament passed Law number 209 of January 2009, establishing a 45-member Constituent Commission, providing for a parliamentary constitution-making process. The Constituent Commission was given an autonomous status and equipped with own secretarial support and services and a budget, having been set at about $5 million. Two important aspects of this procedure must be retained. The first one was that all deliberations were to be taken by consensus, and only in the event that such consensus could not be reached by a majority vote of its members. The consensus principle and the sanction of a majority decision whenever consensus could not be reached had been applied successfully in the South African negotiations 90 to 94. It introduces a subtle variation to the hard and fast majority rule by forcing the participants to seek an inclusive compromise before being permitted to take a majority vote decision. Eventually, and if all goes well, decisions are taken on the basis of an overall arrangement or trade-off pact between the main participants in the process. The other important rule of procedure for the Angolan Constituent Commission was the establishment of a 19-member technical support committee that in some ways one could think assumed a sort of a role as the Herrenchiemsee Convention in the making of the German Grundgesetz. This 19-member technical support committee gathered virtually all the country's constitutional law-making capacity. It reunited experts and practitioners under the leadership of a very influential but also academically respected colleague of ours, Professor Feijóo. The workings of the committee provided for a complex narrowing down process, scheduled over a detailed 8 months agenda with deadlines and dates set in advance. By mid-May 2009, a total of 7 drafts had been submitted by the political parties represented in Parliament. The process of reformulating the 7 drafts into 3 consolidated alternative constitutional texts was entrusted to the technical committee, whilst at the same time the Constitutional Commission embarked on a schedule of countrywide consultations, hearings, and public representations. The 3 consolidated alternative texts were published by the Constitutional Commission on 1 November 2009 and subsequently debated and resolved into a single text in daily sessions of the Commission, with rigorous application of the consensus principle, backed up by a majority vote as a fallback step. The final text was submitted by the Commission to Parliament on 17 December 2009. Parliament approved the text 1 month later, on 21 January 2010, with 186 votes in favour, none against, and 2 abstentions, but with the main opposition party, UNITA, having left the session before the vote. As provided for in a 2008 Constitutional Act that created the Angolan Constitutional Court, the draft constitution was submitted on 25 January to the Constitutional Court for an anticipated constitutional review, the testing yardstick being the substantive or eternal principles that had been set for this constitution-making process already in the 1992 interim constitution, which was still in force. In a 6-to-1 votes judgment on 1 February, meaning 6 days after submission, the Constitutional Court cleared the text but demanded 2 improvements regarding the appointment of the future Deputy President and an improved designation of the candidate in the procedure provided for the election of President. There is, of course, a controversy which caused the main opposition party to not participate in the final vote, and this was a rather original but also very controversial, peculiar form of selecting a president. The broader and more general Mr. Lyman. The opposition's withdrawal of its support at the last moment, when it boycotted the final vote in Parliament, had to do with the opposition's public commitment to a direct election of the President, which it simply could not revisit. But it did not refute the conclusion that the constitution-making process achieved the buy-in and inclusion of all relevant forces. The controversial Angolan choice for the election of the President, termed by Feijó as a parliamentarian presidentialism, provides for a single ballot to elect both the members of Parliament and the President. Article 109 of the new Constitution provides that the first name appearing on the winning list of candidates as members of Parliament shall be deemed to have been elected as President and Head of State. No particular vote by Parliament is required, and defying constitutional practice and teachings, the President can dissolve Parliament, but Parliament can only indirectly trigger the eventual removal of a President by initiating impeachment procedures. The true selection of a President has thus been shifted away from a direct competition for the votes of the electorate, and is in fact to be taken by the highest decision-making body of the majority party that draws up the list of candidates for elections and determines who will appear first in that list. And this leads me to a brief outlook on what we might expect of constitutionalism in Africa. As has been rightly argued and shown by Jeffrey Herbst in his treatise on states and power in Africa, the African state is characterized by its lacking ability to extend, or as Herbst put it, to project power and authority over the greater part of its territory and peoples. It needs to be remembered that the African land mass is enormous. It has 30 million square kilometers, and this is so large that you can fit into it the entire United States of America, India, Western Europe, the entire China, and Argentina. To illustrate the problem, before the first general elections in Mozambique in '94, under United Nations supervision, the largest circulating newspaper in Mozambique printed just 20,000 copies for 16 million people, distributing 98% of the print run in the capital city. The decisions made known in the official government gazette became known mostly by chance, and very often not at all, in any one of the 128 districts, most of which had no electricity, nor telephone or radio communications. The cost and difficulty of extending modern administrative functions and what early Prussian constitutional thinking referred to as the Daseinsvorsorge, the provision of men's most basic needs, is compounded by the enormous ethnic, linguistic, cultural, religious, and historic plurality of the people in all but 3 countries in Africa. The disintegration of inherently frail states and the emergence of what we know as failed states, meaning a situation of lesser or greater anarchy, is not encouraging liberalism or any deliberate strengthening of opposition politics. The Angolan Constitution illustrates the response of African political elites to the threat of state disintegration under circumstances of extreme poverty and underdevelopment. Not surprisingly, it actually achieves a partial reception of the political management system of the People's Republic of China. The Chinese model is a mutation of the old Soviet concept of the state as an instrument of the dominant vanguard party, the Communist Party. With its close of 40 million members, it functions mostly as a rigorous selection system for political talent and leadership. A pyramidal hierarchy replaces institutionalized political competition. But decentralization and limited autonomies are meant to reduce the diverging tensions. As a colleague from Chiangtang University in Hunan province, also known as the Mao University because it was established in his honor and at his birthplace, put it, instead of organizing a multi-billion-dollar public battle and spectacle every 5 years to select a president through the whims and accidents of large ballots, we have a 25-member Politburo composed of the wisest and most resilient and disciplined leaders who select the best available candidate for the office of the next chief executive or president of the country. And this is exactly what the Angolan Constitution opted to do. The newly found attraction of the Chinese model has much to do with China's recent engagement in Africa and its ability to portray impressive development advances, especially in providing education, health, food, security, electricity and transport infrastructures throughout a vast and impoverished realm. Trade between Africa and China in 2009 totaled just over 120 billion US dollars, with a balance vastly in favor of Africa. Chinese credit lines to the 12 most favored countries in Africa totaled in 2009 just under 50 billion US dollars. Not only Angola, but most recently also manifest in the constitution-making processes in Ghana and Kenya, less political pluralism and a more controlled form of constitutional democracy seem to promise better responses to the development challenges that continue to face countries in Africa. This is balanced, however, and we can see this again in the Angolan constitution, with a very careful attempt to safeguard the position of the individual and to safeguard the rule of law. As an example, the limitation clause on fundamental rights in Article 57 is exemplary. It reads, "The law may limit the rights, freedoms and guarantees only in those cases where such limitation is expressly permitted by the Constitution, provided that such limitations shall be limited to that which is necessary, proportional and reasonable in a free and democratic society for the preservation of the other rights or constitutionally safeguarded interests." The direction of constitution making in Africa has changed. From endeavoring to simply establish and consolidate power up until the 1990s, constitutions today attempt to find a balance between the need to ensure long-term developmental planning and progress and the desire to grow and indigenize the rule of the constitutional state, so that our common ideal is preserved, that the rule of law shall replace the rule of man. Thank you.
Thomas Hausen'a da son derece ilginç konuşması için teşekkür ediyorum. Özellikle Anayasa Yapımı'nın bazen nasıl bir zorlu süreç geçirdiğini de Afrika örneğinde bize çok iyi anlattı. Şimdi benim önümüzde yarım saat daha fazla bir süre var, tartışma diyoruz. Burada soru sorulabilir, tebliğ olmamak, korsan tebliğ olmamak koşuluyla küçük bir katkıda bulunabilir. Söz almak isteyen varsa kendilerine söz vereceğim. İsminizi de söylerseniz.
Maalesef English today soracağım. My name is Larry White. I'm from Togo University School of Law, an American lawyer here. I'm also the American Bar Association liaison to the Turkey Barolar Birliği. My question is primarily directed to Professor Kay, but the others are welcome to join in if they should like. First off, do you see referendum as key to popular support of a new constitution? And secondly, with your comment, I think which is correct, is the limitations of referendum, which are basically either an up or a down vote. Would you see possibly a two-phase constitutional process whereby in a first round, perhaps academics or others would pose a number of questions to the people for referenda to get direction with regards to a second phase of the actual drafting? Okay. Thank you very much.
If I have one point in my attitude towards these questions, it is, and I hope I said this a few times, is it all depends. There may be circumstances or historical traditions where it will just be impossible for a constitution to take root, even immediately, without some form of referendum. But there may be other jurisdictions, other places where that's not the constitutional tradition, and where the downside of a divisive referendum campaign might be predominant. And again, I'll defer to my colleague, but I know that the South African process was one where it turned out there was no referendum, but people, I think, were worried about a referendum, and the process which had been laid out was one where, after a certain number of failures, there might be a referendum. And this was an incentive for a number of the parties to come to an agreement. So in that respect, it might have been useful. It might have been a useful device. As to variations on referendum, again, one of my points in this thing was there are an infinite number of variations for all of these possible sets of machinery. The referendum, no matter how it's sliced, is going to be a blunt instrument. But that doesn't mean that the only possible way of proceeding is a straight yes or no vote. I mean, there's and perhaps one of my colleagues will be able to remember the case. There certainly have been referenda in which two different constitutional forms have been placed on the ballot, a parliamentary or a presidential form of government, for example, and then after that referendum, there was then a drafting of the Constitution. So again, my main point always is the possibilities are infinite, and what's necessary is a sensitivity, first of all, to the historical traditions of the society involved, the current political situation, but always, of course, with an eye on the future to how this process will enable or will prevent the Constitution being accepted for a long time.
Teşekkür ederiz. Evet.
İsmim Mehmet Gülerman. İzin verirseniz sorumu İngilizce sormak istiyorum. Richard K'ye soracağım bu soru. My question is related to a personal concern, if I may. You know, the elected legislature, the majority in the parliament, usually claim to base their actions on the will of the people. But if I remember correctly, you have asserted that the will of the people is not a real thing. So there is a material risk that the Constitution will not be the actual reflection of the will of the people, what people feel about their Constitution, the future of their country, and so on. So I wonder, to what extent should a constitutional change be allowed to alter the fundamental values and principles of a country? And what should be the safeguard of those fundamental values and principles in a country, if there should be a safeguard? One may refer to the classical argument in that respect. There are unamendable provisions in the Constitution. However, the provision that claims that those provisions are unamendable is not unamendable. So, I wonder what you think about this.
You asked a lot of different things, and I hope I remember all of them. As to the last one about amending the unamendability provision, I mean, you can put in the list of unamendable things the unamendability provision. That's an easy technical solution, but of course it doesn't make any difference. At the end, no constitution can survive, no matter how ironclad the rules that are written into it, if it ceases to fit with the long-term, widely held needs of the society. And then the question only is whether the form of change is one that is able to invoke the prior law, which has a certain utility, in some cases has a certain utility because it puts a cloak of legality on the constitutional change, or by altering, by simply ignoring the law. And there are some circumstances, I must say, where it's quite the contrary, where the better political course is to break the old law, rather than to try and invoke its authority, because we want to show that we are opening a new chapter in our history. As to the question of, should a constitution violate the fundamental values and beliefs of society, and this is not a legal question. It's only it's a political, social question, and the answer is should, could, would. It can't. Finally, the priority is the underlying social factor. The law has to be a reflection of that. I can qualify that, however, because it's more complicated in the sense that sometimes the value of legality and legal regulation is an important social value, right? So then that has to be, there's kind of an endless regress in which you have to take these things into account. I hope that's of some light on the subject.
İzmir Barosu Başkanı Avukat Özdemir Sökmen, ben Sayın Thomas Hausen'e bir soru sormak istiyorum müsaade ederseniz. Efendim, kendisi anayasaların 4 şekilde meydana getirilebileceğini söyledi. Referandumun da bunlardan bir tanesi olduğunu ileri sürdü. Türkiye'de yakın bir zamanda bir anayasa değişikliği yapılacak ve hükümet de böyle bir yol izlemeyi düşünüyor. Yani referandum yolunu izlemeyi düşünüyor. Kendisi şimdiye kadar bu konuda çok tecrübeli. Az evvel özgeçmişini dinledik. Bu referandumlar yeterli bir anayasa için uygun mu acaba? Kendisi nasıl düşünüyor? Veyahut da bir anayasanın en iyi ne şekilde meydana getirebileceği konusunda bize ne söyleyebilir? Teşekkür ederim.
Thank you. I think it has been noted I'm not a friend of the referendum technique. I always considered the referendum to be like a bit the sledgehammer method. You can use the referendum to really shut up the dissidents, to silence those who were sitting on the fence or who couldn't find a way to buy in. Once you show them that there's an 80% support for the solution that the government is proposing, then hardly anybody can argue against 80%. But this also will rub salt into the wounds, will close the door to the buy-in of the people that are not entirely happy. And as Carl Schmitt has so aptly demonstrated in his books, the only thing interesting really in a referendum is who asks the question and who formulates the question, because that determines the outcome of the referendum. But be that as it may, the senior people in a country, the elite, the political elite, may very well have good reasons to say a particular issue should simply be put to a referendum, so that you can also put it to rest, so that one establishes clearly once and for all where the fault lines are. This can backfire. ZANU-PF in Zimbabwe in 1999 was absolutely convinced that they would get a huge majority for their new constitution in a referendum, and the opposite happened. The people with a resounding majority said no, we will not have a constitution that will just simply prolong the life of the post-independence camouflaged one-party dictatorship. So it really depends how you fight against it. And of course, if you have constitutional review procedures or a constitutional court that could also intervene, then you can probably also safeguard against any abuses in a referendum. The second part of the question was, what do I consider the best approach to it, and I do consider that the negotiate that you have to work on different levels. You have to have an engagement of the key players in the country, of those groups or people that articulate very large bodies of opinion, of association, of culture, of religion, of views about the future, and they have to try and agree on the most general things first. What can we all agree about? We can all agree about the fact that Turkey should be a nation and a state. So you have to make agreement. And from there, you start breaking it down. You come to the things that you can't agree on. You have to devise procedures to negotiate them, have a pact. That's what we lawyers do, especially corporate lawyers who know how to get people to rather to agree than to separate and not. Because we make our money with happy clients and not with unhappy ones. So I think this is a very natural approach. And then this approach has to find legitimacy, has to find constitutional legitimacy. So it has to go either through a parliament that has the power to change the constitution, or a constituent assembly if it has to be, or as a lesser option to a referendum.
Teşekkürler.
Avukat Ömür Dedeoğlu, İstanbul Barosu üyesi. Sayın Sadurski'ye bir sorum olacak. Başarılı anayasalardan bahsetti kendisi. Hangi ülke anayasalarını başarılı buluyorlar ve neden başarılı bulduklarını kısaca özetlerlerse sevinirim. Teşekkürler.
That to some extent connects with the answers given by my predecessors to questions about optimal constitutional process. Although I must say that probably there is no such thing as an optimal constitutional process in abstract terms. It all has to be seen in a specific context, and therefore I cannot say that there is some sort of optimal or best constitution. I can talk about good constitution, obviously sort of like good constitutions which have passed their tests of bringing together very conflictual or divided society and created a degree of legitimacy for common ground rules. And my own country, the country I come from, Poland, is an example. There the constitution was adopted almost 8 years after the fall of communism, after a very drawn-out process. Nevertheless, it was a combination of what my predecessor, Professor Thomas Hausen, just called the pacted constitution. Obviously, the most important issues were decided by largely self-selected representatives of various bodies of opinion in behind-the-scene negotiations, which were then subject to a parliament acting in a constitutional assembly capacity, and then subject to the referendum. So in fact there was a combination of at least 3 models of constitutional process, which produced, I think, a good mixture. And even though particular provisions, both on fundamental ideological issues, the question of reference to God, the question of the model of separation of state and religion, something which in Poland is very sensitive, etc. And of course the questions of separation of powers, presidential versus parliamentary model, etc., were all very highly contested. The constitution was subjected to a referendum, which gave reasonably resounding yes to the product, and very quickly those who in the past were strongly against the project found the way of various ways of living with that and adjusted their political strategies to the institutional framework of the constitution. So I think that constitution became, if you like to use the word, successful. Not necessarily being optimal, not necessarily sorting out all possible frictions between, say, president and parliament, etc., and the government, because this is largely inevitable, but because it obtained a high degree of legitimacy, also thanks, I think, to the referendum. So I would like to put a word in favor of referendum as, not of course, referendum cannot be the only method of parliamentary, of constitution making, but as a way of adding extra legitimacy to it and providing the post-constitution process with an argumentative asset that after all this constitution carries the imprimatur of the people. I think it's a good technique. So it's a combination of all these various procedures plus goodwill of main political actors makes for a good constitution.
Teşekkürler Sayın Sadurski. Evet, buyurun.
Hasan Dursun, planlama uzmanıyım. Benim de sorum Thomas Ausen'a olacak. 1919 yılında Weimar Almanya Anayasası kurucu bir meclis tarafından yapıldı ve bu anayasaya katkı sağlayan da çok ünlü bir dünyaca ünlü bir sosyal bilimci Max Weber vardı. Fakat bu anayasa çöktü. Böyle bir çok başarılı bir anayasanın çökmemesi için ne yapmamız gerekiyor?
Thank you. This is a very challenging, very lovely question. If it were allowed to answer a question with another question, I would pass it on to Professor Kay and say, why is this strange animal, the American Constitution, so successful? Because it actually contradicts all our wisdom. It's made up of all sorts of small amendments. It seems unreally outdated, but it is probably the most successful one. And maybe that's exactly what faulted the 1919 Weimar Constitution, that it was a typical German work of art. It was just totally perfect, totally inadequate, totally unrealistic, completely lacking in pragmatism. It was also inflexible. And, well, as we can all read in the history books, the electoral system didn't help. The lack of attention to the role of political parties to sustain a constitution probably faulted that constitution together with a number of historic consequences. You have to make constitutions in situations of extreme emergency. And Germany, after World War I, was a country in extreme emergency. It had become economically unviable. The conditions of peace were such that the German economy was unable to survive. It is today undisputed. So if you try and make a constitution for a country in extreme emergency, then you cannot design a perfect liberal constitution. This is probably what, with great wisdom, motivated the Angolan constitution makers to opt for procedures that will guarantee a stable government, that will allow for government without becoming the victim of the huge political conflict, drama. In a country in an emergency, there will be drama. There will be groups of people that are prepared not only to be very absolutist, very angry, but also prepared to apply violence to their aims. And then the procedures in Parliament are such that this can render the executive powerless. Then, of course, the whole system is set up for failure. So I would say the luxury of the Weimar Constitution was unaffordable in 1919.
Birkaç dakikamız kaldı. İki istek var. Müsaade ederseniz son söz her zamanki gibi hanımların olsun. Önce siz sorun, sonra Ece Hanım'a son söz sorun.
Teşekkür ediyorum. Ben de Sayın Başkan'ın nezaketine katarak kısa bir soru soracağım. Böylece son ve uzun tutabilecek bir söz bırakmaya çalışacağım hanımefendiye. Benim sorum Sayın Sadurski'ye, Ankara Üniversitesi Hukuk Fakültesi Araştırma Görevlisi Ersoy Kontaç'a. Referandumun özellikle Polonya'da çok önemli bir işlev gördüğünden bahsetti Sayın Sadurski. Ben de Türkiye'deki geçmiş uygulamalardan hareketle şöyle bir görüş ortaya koyacağım ve buna katılır mı onu merak ediyorum. Referandumlar, öyle sanıyorum ki bir anayasanın bütünüyle kabulü veya reddi veya tek bir maddenin kabulü veya reddi söz konusu olduğunda anlam taşıyor. Ama örneğin 8, 12, 25 maddelik ve pek çoğu da teknik düzenlemelere ilişkin maddelerin bir paketin referanduma sunulmasında halkın vereceği cevabın siyasal iktidara duyulan sempatilerin oynamasının dışına çıkamayacağını düşünüyorum. Teknik sebeplerle. Dolayısıyla bir anayasa yapım yöntemi olarak referandumun ancak bu iki ihtimale, yani tek bir veya bütün anayasanın oylanması ihtimallerine ilişkin olarak saklı tutulması gerektiğini düşünüyorum. Buna ne derler? Teşekkür ederim.
Well, the argument that when a particular package is presented to the people, then the response is always incoherent because the package may consist of various different items, and yet the vote is always on the package as a whole, applies not just to referenda on constitution, but to normal parliamentary elections as well. I mean, we take our decisions on which party we want to vote, and yet there may be 10 different items which divide various parties: foreign politics, economic politics, social policy, etc., etc. And yet we have to give our vote on the package as a whole. We cannot say, I approve party A on foreign politics and party B on domestic politics, etc. So we have to vote on, if you like, certain, sometimes the vote is irrational because we like the image or the way of dressing of the leader. Sometimes much more rational because we approve ideologically an overall program of a particular party. And I would say this is also the case in constitutional referenda. Even though obviously constitution consists of a great number of articles, it ideally has a certain coherence which can be summarized in a way which is meaningful and relevant to the people who will vote on it. In fact, I would say that my view is almost opposite to what you have said. When there is a constitutional amendment on something very specific, I do not see any special reason for a referendum. Then I think the purely parliamentary mode, or some sort of enhanced parliamentary mode with a special qualified majority required for an amendment, is all that is needed, like in France, for instance, where you have to have first the majority, simple majority of both chambers, and then when there is this support, both chambers meet together and 3/5 is required. There was a specific constitutional constitutional amendment in Poland 2 years ago. No one almost noticed it. It was about adjusting the extradition provision to the European arrest warrant. However, and then I think that the referendum on a single article is probably useless because referendum gives a certain weight of legitimacy to a constitution as a whole, which may serve as an argumentative asset to those who, after the constitution is adopted, would not like to comply with this. I mean, it's an important, it's not a definite and conclusive asset, and yet it is an asset, it's an argument. That is why I think it's useful for, if you like, not from great ideological reasons, but for political pragmatic reasons, to end up the constitutional process with this final step, and that is the national referendum.
Doçent Doktor Ece Göztepe, sorum Sayın Profesör Sadurski'ye. Kendisi Anayasa Mahkemelerinin aktivist olması halinde anayasanın tek yorumcusu olma tehlikesinin mevcut olduğunu söylediler. Aslında bu saptama Türkiye için de sürekli ateş altında olan Anayasa Mahkemesi için geçerli. Türkiye'de de Anayasa Mahkemesi'nin meşruluğu ana tartışma konularından bir tanesi her anayasa değişikliğinde. Ama burada biraz da bütün bağlamı görmek gerekmiyor mu diye sormak istiyorum. Çünkü Roma hukukunun bugün de geçerli olan ilkesi davacının olmadığı yerde dava olmaz. Dolayısıyla Anayasa Mahkemesi'nin önüne bir dava gelmesini engelleyecek bir şekilde diğer siyasal toplumsal aktörler bir uzlaşma sağlama yetisine sahip iseler, bu durumda Anayasa Mahkemesi'nin anayasayı yorum tekeline de ihtiyaç kalmayacaktır. Acaba bu paradoksun optimal bir çözümü konusunda bir fikri var mı? Teşekkür ederim.
I don't want to say anything about the Constitutional Court in Turkey because I don't know the situation and I don't want my comments to be seen as making some sort of dispensing my wisdom on something that I'm totally ignorant about. However, what you mentioned is a very, very huge issue with respect to constitutional courts in various post-authoritarian states and I think in particular about post-communist states. I do not necessarily mind the very idea of an activist court. I think that courts should be activist, that is, should be brave and not be timid in offering their interpretation of the Constitution, even if it's inconsistent with the interpretation provided by legislative body. What I do worry about and object about the Kelsenian model of constitutional review as applied to post-authoritarian states is that it is not so much a matter of activist model, but so centralized a model of constitutional adjudication that it basically provides for a monopoly of constitutional and exclusiveness of constitutional adjudication, and therefore deprives regular judges, as I think they should, to set aside, to disregard the law which they consider unconstitutional. And therefore it somehow concentrates the institutional, quote-unquote, constitutional wisdom in one body, which not necessarily is composed of people who have the highest wisdom, legitimacy, competence, etc., to decide about true constitutional meaning, and at the same time deprives all other judicial and political actors, and in particular regular judges, of making their own judgments about unconstitutionality of laws, which I think has negative impact for constitutional culture as a whole. So I would see, do I have any remedies, some sort of hybrid model in which both constitutional courts would be there and could be activated by political actors, by members of parliaments, by president, government, etc. But at the same time, very strong decentralization of constitutional review with regular judges being able not merely to ask their respectful questions to the Constitutional Court about whether the statute that they consider while considering a case is constitutional or not, but which would have actually the power to set aside laws which they consider unconstitutional.
Teşekkür ederiz Sayın Sadurski. Oturumu açış konuşmamda oturum sonrası pek çok yeni ve değerli bilgilerle donatılmış ve böylece Bacon'un deyimiyle kendimizi yüceltilmiş hissederek toplantıdan ayrılacağımıza olan inancımı sizlerle paylaşmıştım. Bu beklentimin fazlasıyla gerçekleşmiş olduğunu söylersem sanırım sizler de bana katılırsınız. Bizleri bugünlerde ülkemiz için son derece önem taşıyan konularda aydınlatan konuşmacılarımıza, Sayın Sadurski'ye, ve Thomas Hausen'a kendim ve izinde sizlerin adına. Bizleri dikkatle dinleyen ve sorularıyla değerli katkıda bulunan siz konuklarımıza da yine kendim de izinleriyle konuşmacılar adına teşekkür ediyor. Hepinize esenlik ve mutluluklar dileyerek oturumu kapatıyorum.
Ankara Barosu Başkanı Sayın Avukat Ahsen Coşar'ı kürsüye davet ediyorum. Bildirilerini sunmak üzere değerli konuşmacılar, Bilkent Üniversitesi öğretim üyesi Sayın Profesör Doktor Ergun Özbudun, Berlin Freie Üniversitesi öğretim üyesi Sayın Profesör Doktor Sigrid Boysen ve sizlere dağıtılan programlarda gördüğünüz üzere Columbia Üniversitesi ve Collège de France öğretim üyesi Sayın Profesör Doktor John Elser'in de bugün aramızda olması gerekiyordu. Ancak rahatsızlıkları nedeniyle bugün aramızda katılamadılar. Bu nedenle kendilerinin de af dileklerini iletiyoruz. Oturumumuz başlıyor. Buyurun efendim.
Değerli konuklar, sevgili meslektaşlarım, sizleri kendi adıma bu oturumda birlikte görev yapacağımız çok değerli konuşmacılar adına sevgi ve saygıyla selamlıyor. Böylesine önemli bir etkinlikte bu oturumun başkanı olarak görevlendirmekle beni ve benim şahsımda Ankara Barosu'nu onurlandırdıkları için Türkiye Barolar Birliği'nin değerli yöneticilerine kendi adıma Ankara Barosu adına teşekkür ediyorum. Sevgili Ergun Özbudun hocamızın dilimize kazandırdığı çok önemli ve değerli eserler var. Bu eserlerden bir tanesi de Anayasa ve Anayasacılık